Hello, everyone. My name is Crystal Hudson, and I'm ruling in favor of the plaintiff. AU Hospital was in direct violation of the plaintiff's privacy. Access to intimate details and information is controlled by an individual's right to privacy. According to the American Medical Association of 2001 Ethical Principles, they also stated that the patient has the right to confidentiality. The physician should not reveal confidential communication or information without the consent of the patient unless provided for by law or by the need to protect the welfare of the individual or the public interest. And HIPAA treats such a disclosure as a permitted disclosure. And in this case, the plaintiff was not hurting anyone or was going to hurt a group of people or hurt themselves. So therefore, the subpoena that was issued to AU Hospital was not valid because there was not a protective order put in place behind it. And according to HIPAA can disclose PHI to law enforcement without the individual sign HIPAA authorization in certain incidents. And these are some of the certain incidents. To report PHI to law enforcement, officially reasonable, able to prevent or lessen a serious and imminent threat to the health or safety of an individual or the public. Also to report PHI that the covered entity in good faith believes to be evidence of a crime that occurred on the premises of the covered entity. To alert law enforcement to the death of the individual when there is a suspicion that death resulted from criminal conduct. When responding to an off-site medical emergency and necessary to alert law enforcement to criminal activity. To report PHI to law enforcement to report PHI to law enforcement when required by law to do such as reporting gunshots or stab wounds. And this is the one that would stick to the current case. To comply with a court order or court order warrant, a subpoena or summons issued by a judicial officer or an administrative request from a law enforcement official. But the subpoena, the administrative request must include a written statement that the information requested is relevant and material, specific and limited in scope, and de-identified information cannot be used. Also, to respond to requests for PHI for purposes of identifying or locating a suspect, fugitive, material witness, or missing person, but the information must be limited to basic demographic and health information about the person. To respond to a request for PHI about an adult victim of a crime when the victim agrees or in limited circumstances if the individual is unable to agree. Child abuse or negligence may be reported without a parent's agreement to law enforcement official authorized by law to receive such reports. So, ANU Hospital was in direct violation of the plaintiff's privacy and as well as PHI because in these circumstances that is listed as to when a person's information can be given without their information without their signature or authorization, those guidelines was not followed by the AU hospital. The plaintiff was not going to harm anybody. There was no criminal activity as what was stated in the case. So therefore, hospital was in direct violation. So I hope that my consideration is taken as to why I am agreeing with the plaintiff. Thank you for listening and have a good day.